Okay, we have now addressed the action for annulment and the preliminary references, and as I would like to remind you that preliminary references can be divided in two. Preliminary references relating to the interpretation of a community act or a community rule, can be a treaty rule, and action of preliminary reference relating to the validity of an act when during a national court proceeding you raise the invalidity of the provision of a directive, the provision of a regulation, and the national judge cannot decide himself to invalidate the provision. If he has a doubt as to the invalidity, he's in a position where he needs to refer the case to the Court of Justice to ask the Court of Justice to rule on the validity. Now, there are other type of actions. The two actions we will review here is first the action for failure to act, Article 265 of the TFEU. We are in a situation where there is an obligation pending on an institution to adopt an act, but that institution doesn't adopt an act. In that situation, you can call on the Commission to act, or another institution, if that's the case, to act within 2 months. And it's only if the Commission fails to act within that period of 2 months that you are in a position to start your action before the European courts. Now, if you look at the standing is pretty much the same. You need to demonstrate a direct and individual interest, i.e., you can't ask the Commission to act if you have no interest in getting the Commission adopting a certain attitude, a certain decision. Now, as I mentioned, there must be an obligation for the Commission to adopt a binding act. Failure to address a recommendation or an opinion is not actionable. An important element is that in a number of cases, and you bump into this situation in many antitrust cases, there is no, as such, failure to act. You have a refusal to act by the Commission. In that situation, you will seek the annulment. You will not go after the Commission for failure to act. Very often, the Commission uses that kind of trick to reject complaint, and the Commission rejects complaint on the basis that there is a lack of community interest, i.e., the Commission services are too busy to take care of your cases, and the Commission then rejects your cases. I mean, I'd like to make a parenthesis here, which is not on the slide. There is something which is developing fast within the Commission. You'll see that increasingly the Commission is rejecting complaints on the basis of a lack of community interest, but when you read the decision, actually the Commission goes much beyond the explanation as to why there is no community interest, and very often the Commission basically says that your complaint is not founded, is totally unfounded. Now this creates a major problem. This creates a major problem because by using the failure to act, by using, the community interest to reject a complaint, the Commission limits its duty as to the obligation to give reasons for the rejection of your complaint. So, because the case law says that the Commission is not obliged to go into all the details of your case if it rejects on the basis of a lack of community interest. However, because the Commission is now going on the substance of the case, despite the fact that it uses the lack of community interest, the Commission jeopardizes your chances to go to a national competition authority and obtain that authority takes the case on. Because the Commission goes on the substance and says, I don't believe in that case, I don't think your complaint is founded, but there is no community interest. Now, if you go with that decision before national authority, the national authority will forget about the lack of community interest and look at what the Commission said on substance, and the fact that the Commission said that your case is groundless will jeopardize your chances to have a national competition authority taking the case forward. Action for damages. You can seek damages before the European courts because of a characterized violation of EU law by one of the institutions or by a civil servant of one of these institutions. I mean, the threshold is fairly high. You need a characterized violation, which is often very difficult to demonstrate. I mean, a mere violation is not sufficient. Then, obviously, you will need to demonstrate that you suffered a damage as a result of that violation, and you must show also the existence of a direct link between the injury and the characterized violation. It's important to know that even if a member state did not comply before, with EU law, you can't take the member states to the Court of Justice. You will need to seek damages before national court against that member state. Eventually, the national court will refer a question of interpretation to the Court of Justice if it has doubt that the member state basically complied with EU law. Some special procedures now. We'll be very quick on that. First, the interim relief. I mean, it's fairly important. As I mentioned, it can take some time, especially before the General Court, between the moment you start an action and the moment you get the judgment. Therefore, there is a special proceeding which allows you to actually ask for interim measures. Now, what you will need is that what is called the bonus fumi juris. It's the appearance that your case is founded. Now, the threshold has gone down. That's basically the rule, but the threshold has gone down. And usually, specialists will tell you that all you need to demonstrate on that front is that you're not manifestly wrong. Then you will need to show urgency of your requests. You need to show that you're going to suffer a serious, grave and irreparable damage. Now, let me tell you, you can forget about asking for interim measures on the basis that you will not have urgency, when basically what's at stake is only money. For example, if you are seeking the annulment of a cartel decision and of the fine which has been imposed on your company, there is hardly any chance that you will be awarded interim measures. Why? Because the decision, which basically, the financial damage which you would raise can always be compensated. That's the position of the General Court, except in one specific circumstances, when it could jeopardize the life of the company, in which case, a financial damage could, be sufficient. Financial damage could equate to a grave and irreparable prejudice. And then there is the balance of interests. Well, the General Court, after checking that you are not manifestly wrong, after checking there is urgency, will check the interest at stake. And at the outcomes, the balance of interest will grant or not grant interim measures. A few years ago, I sought in interim reliefs regarding a decision on the marketing authorization. We were seeking the annulment of a decision withdrawing a marketing authorization. And my client was adamant, if the products were taken out of the market, the product would never come back on the market. And we managed to demonstrate that we were not manifestly wrong, and actually we managed to demonstrate that we had a strong case. We also managed to demonstrate that if the products were out of the market, many companies, including the applicant, would be harmed, and the harm would not be simply a financial harm and could not be compensated. So we could do it, but at the moment of the balance of interest, and we knew that that was the difficulty, the President of the General Court considered that there was on one hand the principle of the precautionary principle for health, and on the other hand there were some individual interest, and on the balance of interest he decided that the precautionary interest was more important. Now, this is the reason why the expedited procedure has been created. Now, that procedure was created to deal especially with the merger control cases, because as I mentioned to you, it's very difficult in a competition in antitrust case to demonstrate the existence of an urgency. No, that procedure was created to make it possible for the court, the general court, to render judgments in a matter of 12 months through an abridged procedure. So you have only one opportunity to submit a written observation. There is no exchange of observation between the parties. You only have one shot, and then you have the hearing. The test is, much lower in theory than the test for the interim relief, i.e., you don't need to show that you are manifestly not unfounded. All you need to demonstrate is urgency, and there is no balance of interest. What you note is that actually there are very few cases nowadays which are dealt with through this proceeding, and I'm even aware of cases concerning merger cases, so action for annulment against merger decision, which have been refused the benefit of that procedure. I thank you all for your attention, and if you have any questions, you should get my contact data through the organizer of these conferences.